The matter of Englewood Hospital versus the state of New Jersey. Can we please have appearances of counsel?
John Z. Jackson with Greenbelt, Rose, Smith and Davis for the health.
Paul Croce, Greenbaum, Rose, Smith and Davis, also for the appellants.
Good morning, Your Honors. Tim Sheehan from the Office of the Attorney General for respondents.
Good morning, Your Honors. David McMillan from Legal Services New Jersey for Legal Services and Disability Rights New Jersey.
Good morning, counsel, and welcome. Mr. Jackson.
Chief Justice Radner, Associate Justices, good morning. If I may, I would ask to reserve 4 minutes for rebuttal time.
That's fine.
This case presents the question of whether the New Jersey Hospital Care Payment Assistance Program, known as charity care, violates the Fifth Amendment with of the Constitution with a taking of the private property of the hospitals without just compensation. The appellants contend that it does. And we seek a reversal of the decisions below that rejected the finding of a taking and a remand for determination of just compensation. I'd like to make 4 points to begin with. The first is to make clear from the outset that we are not seeking to invalidate the charity care program and the provision of healthcare, hospital care to poor people. What we look to this court for is a declaration as to the responsibilities of the state to operate that program in a constitutional manner, recognizing the rights of the hospital and the needs in order to be able to provide quality health care to the citizens of this state. The enabling statute has been in effect since 1992. This is 2025. But of significance is that in the last 10 years, there have been decisions from the United States Supreme Court that cause a recalibration of how one looks for and identifies takings of property. And we believe that that is where we are now, and that an application of those provisions, or those decisions rather, will result in a determination by this court that there was a taking of property. The leading case of Horn versus Department of Agriculture was in fact a challenge to a statute in 1937, enacted in 1937, and that case was decided in 2015. The court recognized that there was a taking there and went forward to begin to develop more clearly the standards for a physical taking, and that is what we are talking about here. The provisions of NJSA 262H18.64, what we call the Take All Comers statute, are mandatory. They require all hospitals in the state of New Jersey to provide care to anyone seeking it. That was the holding of this court in Kuchera against South Jersey Health Centers. The statute itself, the text of the statute, has nothing in it that prevents the hospitals from charging or covering their costs. In that regard, it bears some resemblance to the federal EMTALA rule, which requires that emergency care be provided, but does not prohibit the healthcare providers from seeking reimbursement after the care has been provided. There are regulations that were enacted, however, in tandem with the statute when applied that result in the deprivation of rights of the hospitals. Those are the regulations that prohibit the hospital from charging people who are found to be eligible for charity care or from attempting to collect any payments from them. It is undisputed from the factual record in this case that while the hospitals received some subsidy payments from the state, those payments were inadequate to cover the basic costs of providing the care. It's an undisputed and uncontradicted fact in this case. It presents a basic concern that I think should raise the court's attention. When we talk about the hospital, I want to make sure that it's clear that I'm talking about the hospital not as brick and mortar on several acres, but as a property owner. And as such, it has rights. Those include rights protected by the Fifth Amendment to not have its private property taken without just compensation when it's done for a public purpose. The take-all-comers statute is a physical taking. It requires the hospital to take its own property and use it in a particular way. The statute is not a restriction on the use of the property. It requires the actual taking and transferring to other people the property of the hospital. And property in this sense consists of, for example, medications or IV fluids. It includes other medical supplies, includes the facilities of the hospital. It includes the property interest in the people that are working there who are providing these services. The hospital provides those services, and it is similar in some ways to the circumstances of the Horn against Department of Agriculture case. That involved raisins, that the farmers were growing raisins, but under the 1937 statute, they were required to set aside a portion of the raisins for use by the government. That was challenged as a physical taking, that these objects were being taken away from the owner and being used for a public purpose involving the pricing structures within the marketplace. The court held that that was a taking. I would suggest that it's a simple comparison to say, raisins in a box are like pills in a container.
But is the character of the government action here regarding the provision of healthcare to all citizens really comparable to entering the raisins market?
In the sense of there is health of people involved in the hospital setting, and raisins are at best a healthy food. I'm not sure, Justice Pierre Louise, what the point of the question is. There clearly is a difference between being in business and being in the professional calling of healthcare. But does that mean that those professionals lose their constitutional rights? I think not.
So one of the factors under the Penn Central test is the character of the government action. That's why I was asking that question. And you're comparing Horn to this case. So I wanted to understand your comparison to the provision of public health care, of healthcare to the public and the state's action in that arena versus the raisin market.
If I might respond a little bit further, it's, I think, inappropriate to compare Horn and the Penn Central test. Horn said Penn Central doesn't apply in this setting because of the physical taking that was involved. And so while it is true, as you said, that one of the elements of the Penn Central test is the nature of the government action, that is inapplicable here. One has to ask, is there a physical taking? And I would suggest that a couple hypotheticals can illustrate this. If you think of a simple example of a farm where a road for a bypass to a highway is being put down the middle of the 500-acre farm, one could say that that restricts the owner's use of the property. But it is a physical taking of the space that is necessary for the byway. The same thing if one thinks about a piece of legislation saying you cannot, if you're a licensed automobile driver, you cannot drive your car on Sundays because of environmental concerns or gasoline shortage. That is, I think, a restriction on the use of the property. But if the legislation said, if you're a licensed car driver, you must use your car on Sundays to take people in an assisted living facility to the drugstore. That is more than a restriction on use. That is a taking of the private property for the public purpose of advancing health, but without just compensation. Or is there just compensation? The question is, should there be? And I would
Sorry, can
suggest
you
that
say that
there
one
is.
more time? You're arguing that if there were a law passed that says you cannot drive your car on Sundays, that is not a per se takings, and that would be analyzed under Penn Central.
Probably.
But if instead there was a law passed that said every Sunday you have to drive one person from an assisted living facility to a pharmacy, or I'm not sure if that's what you said, but something similar to that, that is a per se taking?
I would suggest that it is, because it requires the property owner to use their property in a fashion that is directed by the government through the statute for the public purpose of, in this hypothetical, advancing the health of some third party. And we know
Just a distinction between an affirmative requirement to do something and a prohibition against doing something.
I'm sorry, would you repeat that, Justice Whitman? Yeah.
Are you simply making a distinction between a law that says you cannot do X and that might impact your property versus a law that says you must affirmatively do Y, and Y is something that serves a public purpose? Is it an affirmative versus negative distinction? Because I don't think I've seen that in takings cases.
It's not quite that simple, I think. One has to look at what is the impact of the regulation or legislation. And when it requires that the property be used in a particular fashion for the government or a third party, that's when we get into the taking thing. So I think there is this distinction between affirmative and negative. And the cases that have involved, that have had a recognition of a physical taking have involved affirmative acts, although that has not been articulated.
So could your argument implicate then income taxes? Because people would have to take a certain percentage of their property and give it to the government for use for a public purpose?
Am I saying that taxes constitute the taking? I'm not saying that.
How are you distinguishing that from your example about the car?
Two ways. The first, simplest way is that there's substantial case law that says money is not subject to the property interest analysis that's involved in the Fifth Amendment cases. And the second is taxing is a real power that the government has. You know, if the state chose to tax to support healthcare, that's probably a good idea. That's a way of meeting its obligation under the statute, where it is outlined that the state recognizes that it's of paramount interest to the citizens of the state to have quality hospital care.
So you just said, I think, that money is not property under the takings clause. And I understand your argument as to pills and saline, that those are physical items of personal property similar to raisins. But labor, where is there a case that holds that labor is either real or personal property under the takings clause?
I think this court's decision in Madden versus Delran Township recognizes that professional services are property. Now, in that case, because of the nature of the law being, responsible or reportable to the court as officers of the court, a unconstitutional taking was not found. But the notion that services are property, that there's a property interest in that, I think can be found in that case as a decision of this court and lots of other cases.
Counsel, sorry, go ahead. You've argued in the alternative that this is not a regulatory taking. And you have just acknowledged in talking to discussing this with Justice Pierre Louis that there is a sort of a common good that attaches in a hospital case that may not attach in a raisin case. How does the quantum of common good play itself out in the analysis of a regulatory taking? What role does it have, and what significance does it have, the degree to which the taking involves something that is sort of universally characterized as a common good?
May I ask you to clarify, Justice Hoffman, whether you're talking about regulatory taking in the context of Penn Central or in the context of Cedar Point and that line of cases? I'm sorry?
The former. A regulatory taking in the context of Penn Central.
Okay, in that case, the Penn Central analysis, if applied here, is very difficult for us. But that's, we think, an erroneous.
I don't want to talk about the general. I want to talk about the issue of common good, right? The issue of recognizing the overarching purpose of the legislation and how that manifests itself in the analysis. What significance does it have? Is there a spectrum? I mean, does the degree to which one recognizes there is a common good, does that then weigh more heavily upon that factor or that analysis? Should we be looking at the degree of common good?
There's no clear answer to that from the case law.
That's why I'm asking.
I'm sorry?
That's why I'm asking.
I would suggest that it is appropriate to look at that, but the fact that there's benefits to society, it doesn't totally eliminate the rights of the property owner. There is a balancing, and indeed the Penn Central test is repeatedly referred to as a balancing test. The challenge of this court is to try and divine if you go that route, and I strongly suggest you should not. You define where that balance point is found. But if you go the route of a physical taking, I would suggest that the case law is clear that the fact that there's some public good that's involved does not matter. It does not outweigh the fact that the property has been taken in a physical way. It's been expropriated in various manifestations, whether it's the pills or the IV solutions or the use of the space or the use of services. So I think it all comes together, weighing in favor of a finding of a taking.
Simple analogies like the one that you gave us before are very helpful, and I appreciate them. But I wonder if this situation is a bit more complicated.
Oh, yeah, I think it is, Chief Justice.
And the question then is, what is the impact of that on the analytical approach that we take? Because if one of us buys a car tomorrow, and a month from now, the legislature passes the law along the lines that you suggested and says you've got to be driving someone for a good purpose to the pharmacy every Sunday. That's one thing. If one of us buys a hospital tomorrow, we know that we're entering a field that is heavily regulated, that has longstanding practices with respect to charity care. And Penn Central, of course, addresses that in its second prong. And I'm wondering if we've oversimplified things in a way that glosses over some of the difficult issues here.
I would suggest, Chief Justice, that the fact that a hospital is part of a heavily regulated industry is not where one should look. I mean, it is hard to think of what aspect of life in the United States is not subject to regulation in some way. Now, healthcare has a lot of heavy regulation, but that doesn't mean that there is not a continuing property interest on the part of the property owners. And that's where I think we would take this case. It's important to keep in mind that as the hospitals are trying to advance a public good, they need to be financially solvent. And I think that a misperception or a mistaken assumption in looking at these cases is that nonprofit healthcare in particular should operate on a break-even or not even that basis. But hospitals need to have a positive margin so they can invest in new technology, invest in taking care of patients. So it's important. What is just compensation is goes into how you solve that, but that's not an issue directly before the court at this time.
So if we were to apply the Penn Central standard, which I understand your position is that we should not go there. Under the second prong, the reasonable investment-backed expectation, is charity care simply a cost of doing business that is understood by all those involved?
In the state of New Jersey, under the present circumstances, I would say that it is recognized as part of doing business, but whether it is fair for a hospital not to be able to cover its costs, putting aside making profits and all of that stuff. The record here shows that there's many years in which the hospitals were not able to cover their costs, even with the subsidies that were received from the state of New Jersey.
How would it?
I'm sorry, Justice.
How would it be relevant? Would your response to the Chief Justice's question be the same whether the hospitals acquired the property or purchased the property before or after the charity care obligation came into place? Because I think the state was arguing that takings law in particular serves to protect owners who can demonstrate that they bought the property in reliance on the non-existence of a challenged regulation, and recovery is denied to owners who are challenging pre-existing regulations as a taking that existed before they purchased the car. That was in your example, but before they purchased.
Yes, no, I understand your question, Justice. I am aware of that point being made in the Attorney General's brief, but in our reply brief, we responded that they are not presenting to the court all of the pertinent law. There are cases, Palazzolo comes to mind, which says that doesn't matter.
Say the case name again.
Palazzolo, Palozzolo.
Mm-hmm.
And indeed, if you look at Loretto, which is sort of like the beginning point in this line of analysis, the owner on whose property the cables had been placed bought it after the law was in place. But the holding in that court, in that case, was clearly that there was a taking, a physical taking, and just compensation was due. What the amount of just compensation would be, it's a different question that the court did not address.
Is your argument that the minute the statute sets up a construct that pays a percentage of Medicaid costs, that construct inherently takes from all hospitals, such that this is in reality a facial challenge? Is that your position, that this taking could never really adequately compensate, and it applies evenly to all hospitals, therefore it's facial? Or is your position that this just does not give us enough, is not fair return, and could be a fair return if those numbers were adjusted, even if they weren't adjusted up to 100%?
It's a complicated question you've asked, Justice Hoffman. I'll try and work my way through it. First of all, the Medicaid reference that you have is a little bit out of place here. I mean, charity care, while it uses Medicaid as a benchmark, is not the same thing. But in any event, I can't speak to the circumstances of all the other hospitals in the state of New Jersey, except to the extent that we were able to develop the evidence. We found that there were hospitals, and in some years, in which the costs were fully covered. Okay, so that they, I think they're in a very different position than the hospitals we represent, where we were able to demonstrate repeated losses, as it were. So I think that it is still an as-applied challenge.
Is there any situation if where charity care would be permissible if there weren't 100% coverage? Because that suggests it's a facial challenge and not an as-applied one.
Well, the nursing home in the associated, I'm sorry, I forget the name, but it's Finley. It's been briefed by both sides.
I'm sorry, I missed what you said.
Finley.
Finley.
Yeah. Okay. Was a nursing home case in which there was a regulation, not a statute, but a regulation that required a certain number of beds to be available for people who couldn't pay. Okay, there was a facial challenge brought to that. The court rejected that. It's brought to this court. The court rejected the facial challenge, but said, we don't have the record of how this is applied. There could be an as-applied taking that could be found, or an as-applied violation in terms of the taking that occurs. So I think I don't want to sound too much like a lawyer, but it depends.
Let me ask it slightly differently. If you prevail, is there a hospital that would not be able to rely on this ruling? It's not receiving 100% recovery for its charity care costs.
I think it depends on how you put forth, how the court puts forth how we prevail. But I do recognize that it would be a precedent that other hospitals would look at, and that candidly is an issue here that the court needs to grapple with.
Because you're asking for a ruling essentially on a question of law.
Yes, exactly.
And that's why, and we're going to proceed with this case regardless, but it sounds an official challenge as a result of the critical question of law that you're presenting.
Well, that's one way to look at it. But again, how is the statute and the regulation being applied, and what results from that? And again, we can show that for our client hospitals, there are repeated losses.
But I thought you said before that just goes to whether the compensation is just. And so here, you're only challenging whether there is a takings to begin with, because if there's no takings, you're not entitled to just compensation. So whether or not someone gets 100% of their costs, or how exactly the cost is determined, is it at the Medicaid rate, is it at a different rate, just does not come into play. I thought you had said earlier that your challenge is preceding that. You're trying to say that this is a takings, and therefore you're leaving just compensation. If this court were to agree with you that this was a takings, you would leave just compensation for remand or another day. Doesn't that make it seem more like a facial challenge? Because whether or not there is a takings does not depend on whether there was just compensation. It precedes whether there was just compensation, and then you get into just compensation once you acknowledge that there was a taking?
Yes, but the determination of whether or not there was a taking depends upon what is happening, what the function or impact of the regulation or the statute is. And so I think it is a factual as applied analysis that has to be utilized.
I have to admit, Counselor, I'm confused, and I want to go back to the Chief's question. Also, who asked a very precise question. If there is a statute that has a formula That formula is based upon Medicaid costs. It's 96% of Medicaid costs for charity care, and then descends from there, depending upon the ranking of your hospital. At no point would any hospital receive what you said before are its full costs, its basic costs. So if that's the case, and that applies to all hospitals, how is this not a facial challenge? Because the formula automatically sets recovery for charity care below an amount that you are saying that a hospital would have to recover. And that applies to all hospitals. Explain to me why this is, if that's the case, why this is an as-applied challenge as opposed to a facial challenge.
I believe, Justice Huffman, it's an as-applied challenge because we have developed the evidence that shows the impact of this particular program on the particular hospitals, and that they are not achieving a fair return, to use that as a benchmark or a point of reference. Now, I understand how there's this broader consequence of a decision in favor of the hospitals on the taking issue here. But to the extent that one is looking at a facial versus as applied, it doesn't mean that there isn't a taking. There still could be a taking in either context.
Is it your position that because you're not receiving 100% reimbursement, it is an unfair system?
That, I think, is the beginning point in the analysis. I think that why aren't we entitled to, again, the basic costs? I'm not talking 100% of what would be the standard charges.
So wouldn't the same analysis apply to Medicare or Medicaid that requires hospitals to bill at reduced or be compensated at reduced rates?
In a certain sense, yes, Justice Patterson. But here is, I think, the key distinction. The case law has repeatedly said that Medicare and Medicaid are voluntary programs, and that if one agrees to participate in those programs, you are not going to have the ability to advance a takings challenge, as opposed to the Take All Commerce statute, which is not voluntary. If you are or become a licensed hospital in New Jersey, you have to do this. And that compulsory participation, I think, has a number of consequences. One, I think it calls into question calling this charity care. I mean, when someone is compelled to give something, one can challenge the use of that term.
Now, prior to the enactment of these statutes, the hospitals themselves had a tradition or a course of practice of taking all comers. Right? Hospitals themselves entertain charity care.
Yeah, I think that that's clear because they perceive themselves as having an ethical responsibility, being good citizens. But in the system that existed before this statute, the legislature provided that the hospitals would receive their costs.
I'm saying even prior to any legislation, the hospitals themselves, as a course of practice, took all comers, right? They didn't turn people away. Well, that's in the briefing, that was traditionally the hospitals what they felt was their responsibility.
At some point, I think that emerges as the sense of mission, but it is not a legal requirement. I think we also briefed the fact that there is no common law requirement that a hospital accept anyone who shows up. That is an obligation that comes out of basic common law principles of misfeasance, malfeasance, and all of that stuff. And it gets modified by statutes that impose a duty, perhaps first in an emergency setting, and then expanding, as is the circumstance, in New Jersey.
So what are a hospital's independent but overlapping obligations to care for indigent patients under, for example, EMTALA or the Affordable Care Act? And how do we disentangle that?
That, I think, probably would go to determining whether or not there's just compensation. I mean, if, the overlap, EMTALA is only emergency care or emergency and stabilization of the care. The take-all-comers statute, covers the whole spectrum of care that a hospital may provide, with maybe one or two exceptions for cosmetic type surgery.
But if one of the things that you're arguing that gets you to a takings to begin with is that it's taking away a hospital's right to exclude, doesn't EMTALA already do that?
And EMTALA takes away to some extent the right to exclude, but it does not take away the right to receive reimbursement for the services provided. And this is, I think, critical. It is one thing for the state in the exercise of the police power to protect health and safety of the population to say, you will take care of people when they show up.
Are hospitals reimbursed at 100% under EMTALA when they provide emergency care?
Just in Spanish, I have to tell you, I don't know the answer to that.
Because certainly reimbursement exists in both statutory schemes, the Charity Care in New Jersey and the federal EMTALA scheme. With reimbursement, as I understand it, but you're suggesting that there's a taking because reimbursement is not at 100% in charity care. I'm just wondering if the same thing applies to that or the ACA.
Well, I think it may depend upon what is available in terms of the resources that can provide a source for payment.
But if the reimbursement is not at 100% in EMTALA, which is a federal program, is there a takings issue with EMTALA? And if there is, how come the feds haven't told us that?
Well,
is there any reimbursement under EMTALA?
I'm sorry.
Is there any reimbursement under EMTALA? I didn't think so from the briefs.
It's going to be part of my response.
Okay.
There is no reimbursement under EMTALA. The hospital is able to initiate, action on its common law right. Workman is entitled to, his fair pay.
Do you mean that just that the hospital wants to be able to send a bill?
I'm sorry, Justice.
Do you mean just that the hospital wants to be able to send a bill? Like that the actual requirement that you're objecting to is that hospitals cannot attempt to collect from certain patients, whereas under EMTALA, you could? Because under EMTALA, there's no compensation at all, right?
Under EMTALA as a program, there is no compensation.
And the hospitals can send bills, and then the person may or may not pay the bill, correct?
Yes.
So is what you're objecting to at core here that you can't send the bill?
It's more than you can't send a bill, you can't collect. The hospital relies on the benevolence of the state in terms of what subsidy it's going to give in any year.
But part of collecting is sending the bill.
Part of collecting is sending a bill.
And
Part of sending the bill is having a right to bill.
Right. But it does sound like the difference, the primary difference between EMTALA and charity care is that with charity care, the hospitals are not allowed to send a bill for services performed under charity care, but with EMTALA, you can send a bill. Even though EMTALA is a similar circumstance where the hospitals have to accept patients in an emergency scenario and provide care. It's the same thing. I understand that EMTALA involves emergency care, but it seems like the difference is, as Justice Wayner Apter said, the billing, the ability to bill.
That is, I think, a significant difference. And then there's also the fact that EMTALA is tied into Medicare. That is to say, if one participates in Medicare, EMTALA applies.
So
But you're not
EMTALA
getting- you're
only
not-
applies to a hospital that receives payments from Medicare, so it is an opt-in. Can hospitals opt out of Medicare or Medicaid?
Can they? In some circumstances, yes. I mean, there are some provisions in some states that require participation in Medicaid or Medicaid.
In your,
I'm sorry,
exper-
Medicaid or
in
Medicaid.
your experience, do hospitals opt out?
Do hospitals?
Do hospitals opt out of Medicare and Medicaid?
No. I mean, the practical consequences of that are enormous. I mean, the population that is covered by Medicare is very significant and provides a source of revenue that hospitals have come to depend on. Medicaid is also a substantial amount of the patient census where the reimbursement is lower. But I mean, it's done because it's required to be done.
I thought you said though, before in response to a question from Justice Hoffman, that this is different from arguing simply that Medicaid reimbursement, for example, is insufficient such that there would be a takings claim to Medicaid reimbursement or to Medicare reimbursement. And I thought your distinction was that those programs are voluntary, whereas this is not. But now it seems like you just said that they're perhaps not voluntary.
Yeah.
Or regardless of whether a hospital would choose to opt out, can they opt out? I thought you just said in some circumstances, the answer was no.
And let me go back over a couple of different steps. First of all, participation in Medicare and or Medicaid is voluntary.
Okay.
And as a result of that, there is no takings claim that can be brought successfully as to Medicare and or Medicaid reimbursement.
And the word voluntary means that a hospital could choose not to participate.
And it is recognized, and in fact, it is the line that is often used in the opinions rejecting the takings challenges. Well, the hospital could opt out of Medicare. They're not required to participate in Medicare. And this is seen in the more recent cases involving the drug pricing statute. Okay, that drug companies are not required to sell the Medicare, but if they choose to do it, they have to accept the consequences in terms of how the pricing is being handled.
Counsel, I still need to go back to a question that we talked about before. Is your argument that not receiving 100% Medicaid cost reimbursement is inherently unreasonable and therefore a taking, or that the formula that the legislature has put together, which starts at 96% and groups a certain number of hospitals at 96% and then decreases by 2%, that is just not enough money, and that a revised formula could be acceptable even if that formula didn't arrive at 100% Medicaid cost for all charity care? Which of those two?
Sort of a Hobson's choice here, I suppose, insofar as if the objective is 100% and you're getting 97 or 96%, how much of a squeeze is that? But if you're getting down to 10%, which is factually supported by this record, it's very different. But the beginning point is, the other alternative, that not receiving at least the costs is inherently unreasonable because it's imposing on the hospital an obligation that we say, and I believe the statute supports this, should be borne by society. Okay, and the United States Supreme Court cases also say that. One of the key purposes of the takings clause is to make sure that the burdens of society are not imposed on only one person or one aspect of an industry. And so I think that brings us back to the point that the state of New Jersey, with this statute, the Healthcare Reform Act, acknowledged a responsibility to ensure that quality hospital care was available to its citizens and to provide a subsidy so that could be provided. That's right in the findings of the statute. So there is, there's been much discussion or debate about whether there's a constitutional right to healthcare. We don't need to go there because in New Jersey, there is a statutory right to healthcare. Kuchara says, person shows up in a hospital, they're entitled to be treated. So
evaluating the reasonableness of the construct, the charity care construct, how do benefits that federal and state and local government provide, tax benefits, for example, factor in?
Thank you. I was hoping to be able to get to that point. They factor in only indirectly, because one has to be clear that for sure in New Jersey, the tax exemption or tax preference treatment that hospitals receive is not dependent upon providing charity care. There's an appellate division case to that effect. Similarly, at the federal level, there is a revenue ruling that explicitly says, there is no requirement to provide charity care. If one provides charity care, it's taken into account in terms of community benefit to the community that the hospital is providing. And there are other ways of doing that, charity care being only one of them. Education is one, screening programs is another. There's a variety of them that's available. So those tax benefits, I think, become something to consider when you're saying, has just compensation been afforded through some other way? But it doesn't avoid the need to address that question after finding that there is a taking. The other point I'd like to address, if I may, has to deal with the notion of public accommodations. There's a large section of the opposing briefs that talks about the fact that hospitals are public accommodation and they have an obligation to be open to the public. We're not disputing that as far as that goes, but that does not do anything to eliminate the right of the hospital when it goes on to provide services and use its own property to be reimbursed for that. None of the cases cited by either of the opposing briefs, supports that proposition. And I think, the most glaring example of that is to point to the Heart of Atlanta motel. Why we're talking about that in this context, I don't know, but we are. There certainly is absolutely no evidence to show that there's been some racial discrimination practiced by the hospitals, these hospitals or any hospital in New Jersey, that justifies the invocation of that case. But here's the key point. Nowhere in that opinion did the court say, while you have to rent to these people, you can still charge the reasonable rent. Now, it's part of the same.
In Heart of Atlanta, the discrimination case.
It's a discrimination case.
And you're saying that it's irrelevant because there was no issue as to whether the individuals or the petitioners could be charged for the hotel?
Yeah, I'm not sure I would say it's irrelevant, Justice Patterson, as opposed to it's a distraction. And the truth is that nothing in that opinion says your property is not being taken. You just can't discriminate, which is a principle I think that this court would readily endorse. But
And that's the case for all the public accommodation cases. For example, the LAD, I think, is also mentioned with a list of what the public accommodations are, but the rule there is not then that restaurants have to provide meals for free to anyone who can't pay. It's just that restaurants cannot discriminate based on race or gender or sexual orientation or whatever the protected categories are listed in the LAD.
Exactly right, Justice Warner after. Okay. So I think that in the public accommodation circumstance, the cases in New Jersey, I mean, there's a whole litany of them. State versus Shack, State versus Schmidt, Houston against resorts, Doe versus Bridgeton Hospital. None of those cases say that although you have to allow access to the facilities, if the facilities are used, there's nothing that prohibits the property owner from receiving reimbursement.
So you may not be saying they're irrelevant, but you're saying they're not very relevant.
Yes. And the other part of that is to just go back to the common law. Innkeepers, the duty of common law is frequently invoked in terms of the cases that talk about the obligation of public accommodations. And, the scholarly studies repeatedly acknowledge that innkeepers are entitled to get paid. They have to provide the lodging, they have to provide the food, but they could charge for it. It gets to be difficult if they start charging discriminatorily prices, but that's, not what we're talking about here.
So we're just about at the half hour mark. Is there anything, I'm joking, you're not looking at the clock. It's all right. Are there other items that you wanted to address before we invite you back for rebuttal?
No, I think I've gotten through my points. Okay, thank you very much.
Thank you. Mr. Sheehan.
Good morning. May it please the court. For decades, New Jersey has required hospitals to admit and provide
Try to keep your
appropriate.
voice up, please.
For decades, New Jersey has required hospitals to admit and provide appropriate treatment to patients regardless of their ability to pay, while providing hospitals a subsidy to offset the cost of this care. Charity care thus follows a long tradition of public utility-like regulation of hospitals, such as rate regulation and common law duties to open their doors to members of the public seeking medical care. Petitioners focus almost exclusively on a claim that charity care works a per se taking, but their theories can't be squared with history or precedent, especially in light of petitioners' concessions. Petitioners first argue that this law deprives them of a right to exclude any patients whom they might prefer not to treat, but this court in Doe versus Bridgeton Hospital held that hospitals enjoy no such right in the first place because that would conflict with their duty to serve the public without discrimination. And the US Supreme Court's recent decision in Cedar Point Nursery itself teaches that this kind of background restriction on property rights disposes of a per se taking claim. Petitioners get no further in objecting that the subsidy covers less than 100% of what they deem the costs of the medical supplies used to treat charity care patients. Initially, petitioners mistakenly frame the thing they've suffered a deprivation of as the individual gauze and bandages. But recent US Supreme Court cases like Murr versus Wisconsin confirm that the inquiry doesn't take place at that level of granularity, and that you instead look at the property as a whole in deciding whether a per se taking has occurred. So just as you don't parcel out each blade of grass to ask whether there's been a taking of an 18-acre plot of land, here the question isn't what happened to each single gauze or syringe, but what happened to the hospital. And charity care's impact on the hospital is again consistent with long-standing restrictions on this type of business. Initially, this is an outgrowth of hospitals' own pre-existing practice, which was codified into laws subjecting hospitals and other public utilities to rate regulation, which petitioners now concede is constitutional. And charity care operates to similar effect. After all, both rate regulation and charity care limit a hospital to receiving a set predetermined amount for a given procedure, and both mean that a hospital receives less than 100% of what it deems the costs of that treatment. So if no taking occurs when the state, through rate regulation, limits a hospital to collecting $1,000, say, for a surgery on a broken arm, then so too when the state designs a subsidy formula to yield the same result by placing the $1,000 directly into the hospital's coffers. That historical tradition of requiring hospitals to accept all comers while setting their rates also distinguishes Horn, where there was simply no relevant historical tradition undergirding a law that required raisin growers to physically hand over their raisins to the government. And even if this court believed that this could be a viable per se claim in the abstract, most of these petitioners still can't assert this claim because they acquired their ownership interest in these hospitals long after charity care had already been the law of the land, and thus would have paid less by baking the price of charity care into the purchase price. That flows from petitioners' decision to litigate this as a per se claim, just as the buyer of a house with a government fire hydrant already installed outside would take her property with that encumbrance and thus could not turn around and sue claiming a taking. Last, petitioners have all but abandoned any regulatory taking claim, and for good reason. They have not shown that the economic impact of charity care is prohibitive. This law does not impinge on any reasonable investment-backed expectations, particularly given the historically highly regulated nature of hospitals that we've been discussing this morning. And this law just the benefits and burdens of economic life for the common good, as the two federal circuits to review similar challenges to charity care laws have found. I welcome the court's questions. Otherwise, I will dive into what I think are both the limits on our theory and I think the problems with the unlimited scope of petitioners' theory. We have relied on a longstanding tradition of regulating hospitals that works in sort of two ways. It treats hospitals as public accommodations that, much like Ollie's Barbecue in the Heart of Atlanta case, cannot exclude patients or customers on discriminatory grounds. At the same time, there's also this tradition of heavily regulating the rates or the costs that hospitals can receive for any given treatment. Petitioners concede in their response to the amicus brief that hospitals are properly characterized as public utilities, and they also concede that rate regulation is a kind of standard and accepted outgrowth of public utility tradition. Those twin traditions, that is what brings charity care in line with these longstanding restrictions on this type of business's use of its property, which is the kind of tradition that Cedar Point instructs the courts to look for. That also demonstrates the limits on this rule. There are not many other industries or businesses that are subjected to both that kind of public accommodation, common carrier tradition, and this public utility rate regulation model where the state superimposes a specific fee structure on that business. So again, the Ollie's Barbecue and Heart of Atlanta, any other restaurant, they may be treated like common carriers where they have this sort of duty to accept all comers, much like the innkeeper of days of old, but they don't have this history of being subjected to rate regulation. And so that's why hospitals are properly subjected to this regime, but that tradition just doesn't do the same work for other industries. And that's why the rule acknowledging that charity care does not work taking here is pretty limited to this scenario and possibly to the one or two other highly regulated public facing industries that have long lived with that kind of twin tradition.
I understand the effort to say that this is unique because it's a combination of public accommodations law and rate regulation, and then to avoid complicated questions like, could the legislature altogether stop funding the office of the public defender and simply pass a law ordering lawyers to provide legal services without regard to ability to pay? I assume your response would be that, lawyers have not been subject to rate regulation and are not a public accommodation in the same way, although I'm not sure. But where do we find that in takings jurisprudence? Meaning, for purposes of takings claims, where does it say the fact that this is either a place of public accommodation or has been subject to rate regulation in the past, it matters for takings purposes?
So I think this is just an application of the framework that the United States Supreme Court has set up and that they recently reiterated in Cedar Point Nursery. When a party is alleging that a government regulation has worked a physical invasion, a per se taking, that alleged invasion does not automatically amount to a per se taking when it's consistent with longstanding regulatory traditions on that type of property or that type of business. And so we are taking that instruction and we're looking at the longstanding restrictions that operate on the hospital industry. And so that's why we think the tradition that is unique to this specific type of business does save this program from their per se claim. And that is a tradition that is somewhat unique to hospitals. That you can find maybe an analog to that for maybe housing or I think pro bono with attorneys. But I think that just flows from the U.S. Supreme Court's longstanding view that you look to background restrictions on this, this particular person's use of property. And when the plaintiff happens to be the hospital industry, that does bring in this deep tradition that has roots in public accommodation, common carrier models, and this sort of public utility rate regulation model. So I can't point you to another takings case that had the exact same tradition, but I think Cedar Point itself instructs courts to look for this kind of longstanding tradition. And there are
I think your adversary, though, pointed out, for example, that in Horn, there was this long tradition that this law had been in place since 1937, where a percentage of the raisins were taken, and that didn't save it. So where do we see that? I see the sentences in Cedar Point where it refers to background regulations. I then didn't find a ton of examples of what would be included in that. But how do you respond to in Horn the fact that this was kind of a long-standing background regulation didn't seem to help?
So I'll address Horn first and then talk about where the examples come from, because I do think there is one in Cedar Point. But in Horn, there wasn't actually a tradition.
I'm sorry, I missed what you said. Your voice trailed off. You said you were going to address Horn and then.
Sorry, second, I will talk about where there are examples of this analysis in Cedar Point itself. Starting with Horn, I do think the problem in Horn was there wasn't actually a historical tradition that undergirded that set-aside regulation. It was just a long-standing law. The law itself cannot provide the tradition. I think that's pretty circular logic. And so if the mere fact that the law had been on the books since the statute had been on the books since the 1930s versus 1990, that obviously can't supply the source of its own validity. I think that would be kind of problematic and would lead to strange outcomes where the more recent law is less constitutional, but the same law 100 years ago. So I think in Horn, that was the problem. And Cedar Point talks about this, that there was not that kind of tradition in Horn. And I think that's the reason why, where the only thing you could point to was that law itself. Obviously, this case is different. We're not just saying because charity care has been around since 1992, or you can trace it back to the 1970s, maybe. It's because it is an outgrowth of first hospital's own practice of doing this kind of as a matter of grace, which then evolved into duties codified into law. To take the second part of Your Honor's question, I do think Cedar Point itself points to examples of how you tie a modern law into those historical traditions. There's some discussion of the Babcock case in Cedar Point, which concerned provisions of the NLRA, which did something a little similar to the California law in Cedar Point. It allowed union organizers access to private property in some circumstances to communicate with employees. The majority in Cedar Point makes clear that their decision in Cedar Point is not overruling or calling Babcock into question. And Justice Kavanaugh explains in his concurrence why that is, even though there was no historical tradition of that exact kind of access regulation particular to union organizers. What Justice Kavanaugh explained is there is this kind of background common law privilege of necessity, and that is sort of analogous enough to the provisions of the NLRA that were at issue in Babcock. And at that sort of level of generality, those were analogous enough, and that's why that part of the NLRA that was at issue in Babcock would still survive under Cedar Point. So I think Cedar Point does give you an illustrative example of when you look at what kind of historical tradition you're looking for and what kind of fit you need. And that's a pretty loose fit, I think, the privilege of necessity and the NLRA. I think there's a much tighter fit here, especially when all parties here agree that this tradition of public utility rate regulation is sort of non-controversial and is sort of ingrained in our constitutional traditions, including in New Jersey. I think even for hospitals, this whole regulatory model, it sort of has its inception in the 1970s, where New Jersey started by directly imposing a fee structure on hospitals for all patients, not just indigent patients, but for everyone, and was sort of a blunt, setting the rate for all, and that didn't really work very well. And so we made tweaks to that, and by the 1990s, we got to this system where charity care imposes this subsidy formula, which operates like rate regulation for the particular patient population, while leaving hospitals free to charge whatever rates they wish for, more well-heeled patients.
Council, I'm going to sort of show my hand early and just tell you what I'm struggling with, which is how low is too low? At what point does this become a taking? So we'll use the formula at hand, right? Let's say there's no longer a 43% floor. Let's say the government the state says, we don't have the money to appropriate anything to supplement the formula, so we have to only rely upon what the hospitals are putting in. Let's say that instead of a cumulative $638 million loss, there's a cumulative $1 billion loss. Where's the line? At what point does this become a taking?
Your Honor, I think that is classically the realm of a regulatory taking claim under the Penn Central analysis, and the analysis that really captures those kinds of questions. And I think what's awkward about this case is that petitioners are so unwilling to have that fight. We're happy to talk about why the state wins even under Penn Central. But I think you can absolutely, if you're a hospital that is at that 43% or you've fallen below 43% and you're saying, you know what, maybe this is fine for the hospital that gets the 96% tranche. For us, it is becoming prohibitive. It's become confiscatory. We can barely operate as a hospital anymore. Under our particular circumstances, we think this is operating as a taking.
So do the Penn Central analysis in that case for us to see how that would come out.
Could I ask you to finish your sentence
sorry.
before we get there?
No, I'm
If a
sorry.
hospital comes to just where you ended there, the hospital makes out that much more concerning case, then what?
I think that is just the first factor in the Penn Central analysis, and maybe I'm rebutting Your Honor's question. That goes to the economic effect of the regulation. You then balance that against the other two factors: the character of the government action and the impact on distinct investment-backed expectations. Those two other factors cut heavily against petitioners, or really any hospital here. I don't think those factors change depending on the hospital, but what the Penn Central inquiry is trying to do is get exactly at Your Honor's question.
So do factor one for us in that scenario.
I
Tell us
think
what factor one in Penn Central would lead.
I think what factor one in Penn Central is getting at there is this crossing a line from forcing you to operate at a loss with respect to these particular patients? Is it crossing a line from that to actually depriving you of all economically beneficial uses of your business as
That's what I thought you were going to say. So if you have to get all the way to depriving you of all economic uses of the property, which it seems like is what you have to argue because of the 1926 Village of Euclid versus Amber Realty, 75% diminution in the property, in the developer's property, not enough. Had a check versus Sebastian from 1915, 87% diminution in value of the property, not enough. Basically, the court is saying, it has to be that you have to be denied all economically beneficial or productive use of the land. How can it possibly be that it is not a taking unless you cannot operate as a hospital at all anymore?
I think,
or you can't operate as anything anymore?
Again, this is a multi-factor balancing test, so there's a little bit of flexibility in there. I don't
You
think
don't
that,
really get to 2 or 3 unless you show enough under 1, and it does seem like what you have to show under 1 is denying all economically beneficial or productive use of the land.
I think that's basically right. And you do have 2 examples of this happening, and we cite the Franklin Memorial Hospital case and the Sierra Medical Services case, the First and Ninth Circuit cases, which also heard Penn Central regulatory challenges to a charity care law. They weren't identical, but it was the same kind of concept. And both those courts looked at what is like the actual proportion of your overall revenues that accounts for these charity care patients. And I think it was in Franklin Memorial, they looked at the percentage, it was very low. But the point was you're looking at that individual hospital and on their books, what does that number show? And I think that's what both circuits said. It has to kind of start to really approach, you simply this is not a viable business as a hospital anymore because of the operation of this law. But I think what an important point that comes out of both those cases is they recognize that hospitals under those laws, and I think the same is true in New Jersey, hospitals don't just treat those charity care patients, they treat all other kinds of self-pay patients, Medicare, Medicaid beneficiaries. They are doing all kinds of other business. There's, checks coming in from the government, from commercial payers all the time. And so to say that for this patient population, we are operating a loss when we had to comply with this state law, it really is a very incomplete picture of a hospital's finances as a whole. And what the First and Ninth Circuits instruct courts to do is you have to look at the overall economic picture in doing that factor 1 analysis. I think that's why it's so hard with this kind of law, that it is pretty tailored and deals with like a kind of smaller population that is also often covered by Medicare and Medicaid. I think that's why it's so hard to make that showing under factor 1. So to come back to Justice Hoffman's question, I think our position accepts that it is theoretically possible that you could make a stronger showing under a Penn Central analysis. But as a matter of practice, when those 2 other factors are so difficult for petitioners, as I think they've conceded this morning, especially with the investment-backed expectations prong, which is especially problematic if you're a petitioner that entered this industry after 1992 when charity care became the law. I think as a practical matter, it is very difficult to make that showing.
So let's stop with where you were with your hospital that falls below 43%. If the law sets the floor at 43%, doesn't that hospital or don't hospitals have a reasonable investment-based expectation that the floor will be 43% and no hospital will fall below that floor?
I don't think so, Your Honor, because of the way this statute operates. My understanding of the kind of tranches of where you fall in the formula is recalculated over time. So if you, on year 1 of you operating as a hospital, you're in the 43% trance, I don't think that locks you into that forever. And so
Also subject to appropriation, so it's really only 43% as a floor in theory, because as Justice Hoffman pointed out, if too little money is appropriated to give anyone 43%, then they're getting 10% instead.
yes, I think that is part of the background understanding of any hospital entering this industry. And that background includes that for decades, hospitals have been living in New Jersey with the state telling them you can charge this much for this patient, but this much for that patient. So I think any expectation of I'm going to be at this percentage or it's going to be this dollar amount every year is really not grounded in anything.
That feels to me then like you're saying that for purposes of a hospital, there is no Penn Central number 2 test. There's number 1 and there's number 3, because you really can't have a reasonable investment-based expectation if you're a hospital because of how highly it has been regulated. Is that what you're saying?
I don't think so. I think that factor 2 is difficult for petitioners in this case because the way charity care operates is so similar to how the pricing regulatory structure has operated in New Jersey for decades. So even if you're a hospital who came into the industry 1 year before charity care's enactment, what it was doing was already so similar to what hospitals have had to deal with for decades. So I think in this case, that prong is very difficult. We're not saying that that is like a dead letter for hospitals in any takings case just because you're a hospital. I think what the Third Circuit said in the United Wire Meadow case is that hospital regulation has historically been very heavy, particularly with respect to price and costs in New Jersey. And so
the expectations just simply are if there's been regulation, no matter what that regulation entails and how much of a financial burden it puts on the hospitals, your reasonable expectations had to be that there was going to be regulation and that ends the issue. That doesn't seem right, because regulation can do so many different things, some of them trivial and some of them destructive to a business.
Your Honor, we're not saying that. I am saying that when you're operating against a backdrop of decades of similar regulations, your investment back expectations in the non-existence of this law are just heavily diminished. I think Penn Central says that, all the cases we cite.
And I get that, but I thought in the realm of hypotheticals where something changes in the future and the floor drops out. So that do you see that as potentially problematic under the second factor?
Sure. I think you can imagine different facts where if the legislature did something drastically different to this regime, where the impact on the bottom line of hospitals, where the floor was pulled out from underneath them, maybe you can make a stronger showing.
It's very hard even when that happens. I'm looking at the case about a zoning ordinance that prohibited brick making despite an 87.5 diminution in the value of a brickyard owner's property. And the answer was, sorry, no problem. So it just seems it's very hard to win a regulatory takings claim because you have to show kind of no beneficial use of the property. And it seems very hard for hospitals to ever show that.
I do agree it is very hard for hospitals to show that, at least with a law that does something like this, which is impose a specific fee structure on the hospital. I do think, and we've acknowledged in our briefing and today, that this is not true for just any hospital regulation. You can imagine different hospital statutes that really have no relation to this history of regulation. But because the state has always so heavily regulated the prices that hospitals can charge and the amounts that they can collect, when the hospital regulation we're talking about is just doing a version of that, I do think those first and second prongs are very difficult to prevail on. And that's not surprising as a doctrinal matter, because what Penn Central is trying to do is just sort of capture things that look like per se physical invasions, where it's just regulation that goes too far. And it goes too far in the sense that it is kind of depriving you, taking your whole property away. So it's not very surprising that if they can't make a per se showing, they also can't prevail on a regulatory taking claim. I'm just simply saying that those factors are not a dead letter just because you're a hospital. I do think in this context, when we're talking about regulating the prices hospitals can charge and collect, those are very difficult prongs to show. And the last thing I'll say is, I do think this case has been litigated really in a facial posture, where this isn't one hospital saying, for me, this is operated in this particular way. These are the numbers. And the way petitioners are litigating this is not at all, rooted in the numbers of particular hospitals. It is this categorical claim that I think the claim is anytime you reimburse us at less than 100% of what we deem our actual costs, that becomes a taking. I think that the theory that they are asking this court to accept really is not grounded in any individual hospital's facts. So a different law, different facts. I can imagine the Penn Central analysis being a little more difficult, but at least in this context, when you're challenging a law that is kind of rooted in this rate regulation tradition that has unfolded over decades, and sort of has its inception in something hospitals were always doing as a voluntary matter, I do think you cannot prevail under Penn Central.
So it feels to me almost that you're trying to take the best of Penn Central, but at the same time ignoring what the implications are. So we don't want hospitals that have old equipment. We don't want hospitals that have to hire bad doctors. We don't want hospitals that are falling apart. But if you're saying that, well, that really is the test. It has to be, where did you use operating at a loss? Or else you don't really get any break under Penn Central. It feels to me like your answer to 1 and 2 is then invading test 3, but to the negative. Because at that point, it's hard to say that this legislation or this action is acting in the common good if it's creating hospitals that are merely still able to function and not have the money to establish programs, diversify their portfolio, hire good doctors, have good equipment. But that's not what we want to do. That's not what Penn Central is meant to incentivize. And it almost feels to me that if you dismiss 1 and 2 in the way that you have, you walk into a problem with factor 3, because it can't be in the common good that we're trying to establish hospitals that just merely get by.
Well, Your Honor, I obviously disagree that this law is operating in that way. And I think a lot of what this court is hearing from petitioners is that they are operating a loss with respect to these charity care patients. I don't know that anyone has made a showing that these hospitals as a whole are struggling to that extent. And that's the opposite of the legislative intent behind charity care. I mean, you can see in the legislative findings, the whole point of charity care was to ensure that hospitals have enough money that they can continue to provide treatment both to patients who can't afford to pay and all other patients. The second thing I would say, though, is that I think as a general matter, Your Honor's question is absolutely correct, that these 3 Penn Central factors kind of rise or fall together. So if 1 and 2 is such a, painting such a dire picture in that way, that's probably going to drag down factor 3, because it no longer looks like this regulation, just reflects an intent to adjust the benefits and burdens for the common good, and it starts to look more like physically invading your property. These are like 3 interrelated factors. The third factor is related to what extent does this look like the government is just sort of forcing you out of business. I don't think that's this case. I think that's the opposite of what this legislation was intended to do. And so I just think that's a very different case. But I think the thrust of Your Honor's question is correct as a doctrinal matter.
You said that there's been no showing of the concerns that Justice Hoffman just identified. If that were the standard, would we be looking at an as-applied challenge?
Yes, I think that is really the realm of an as-applied challenge. And the 2 Federal Circuit cases we cited that dealt with a similar law, it was specific hospitals, often one hospital, kind of showing their books to the court and really grounding their arguments in the numbers. So we absolutely accept that you can bring an as-applied challenge under that Penn Central framework. I think petitioners have sort of walked away from that and are really trying to focus on this per se theory. That's why we've really briefed before this court, we briefed this as a per se case. I think the kind of categorical claim that petitioners are making, kind of trying to shoehorn this into per se, is why it's been so difficult for them to make any strong showing under any of those 3 factors.
But their expert report has data relating to these hospitals. So it's not entirely a global sort of philosophical claim.
Absolutely, Your Honor. And there's a record in this case. The appellate division looked at that report, looked at the whole record, and we completely embraced the appellate division's analysis of the 3 Penn Central factors. We think the panel, quite frankly, got this right in looking at the 3 factors. They even credited petitioners on factor 1 by noting that they are operating at some hospitals are sustaining losses from charity care patients. But I think the panel also noted that it is not depriving them of all economically beneficial uses of the property. And so there still is this very high bar for factor 1 that petitioners had not met here. But I think the kind of as applied Penn Central claim we're talking about now, that's what was litigated below. And we think the appellate division came out in the right place. Petitioners kind of really shifted more to this physical invasion theory here. And so we focused on that. We think that also fails, but
Could the legislature pass a law ordering landlords to provide housing regardless of a tenant's ability to pay? It seems like landlords are subject to the same anti-discrimination laws as places of public accommodation, and in some circumstances are considered places of public accommodation. And it seems like they're probably also subject to the same type of rate regulation that you're referring to, in that rent control has been challenged and rejected.
I think you would look for evidence of a similar tradition for landlords. I haven't studied this closely, so I don't want to give a definitive answer. But I do think there is a history of rent control that obviously the Supreme Court in Yee upheld that as not working a taking. So if you conceive of a program that looks and walks and operates a lot like rent control or rent stabilization, I think that would probably pass a per se inquiry. The more it looks like something different from that, and where you're saying they don't have to pay rent at all, I think that's a closer case. Obviously, in the rent and mortgage context, there have been certain emergency measures that courts have upheld under a Penn Central inquiry, both in the kind of Great Depression and then in COVID-19. So those might be kind of.
But then it seems like you're just relying on the fact that the legislature hasn't gone that far, but you're still saying there would be no prohibition on them going that far. So if it's not a per se taking because there's no invasion, because you have to rent to anyone without regard, you are not allowed to discriminate in renting an apartment. And there has been this history of some amount of rent control, so that there's no per se claim, and then there's no regulatory takings claim because you can't show no beneficial use of your property, because presumably some people would still be able to pay rent. I'm just not sure, how do you not fall into the argument that petitioners make that this is just an example of the legislature taking something that impacts the entire public? So the need for affordable housing, that is really a public need that impacts everyone, and just forcing one segment of the population to pay for it, to say, we're not going to have public housing anymore, government's not going to subsidize this. From now on, landlords just have to provide apartments for free to anyone who can't pay. That seems to be the core of petitioners' argument, that the need for quality healthcare is a public need, but instead of the state funding it, the state is just saying, you private entity instead have to fund it.
I think the landlord in that case has a much stronger per se and Penn Central claim, but I think that's also very different from what's happening here. The state is not just saying, hospitals, you go provide this at your own cost. The state is saying you have to provide access and care to these patients, and you're going to receive a direct state subsidy that offsets much of that cost, not 100%, but much of that cost. It's designed to be enough of a subsidy that you can continue to profitably provide that treatment, not only to those patients, but to everyone. And so
I thought you were just kind of saying that the amount of subsidy is not related to, you'd have to show under Penn Central, under per se, you're saying it's not a per se example at all. And it doesn't have to do with how much of the subsidy is paid. You're saying it's not per se because there's no invasion. You can't look at it at the level of gauze or saline, et cetera. And then on Penn Central, I thought you kind of ended up acknowledging that as long as there is some beneficial use of your property, then you're kind of out. So how do you then, I understand that this is not the hypothetical. I'm just not clear on why under the law that matters, where you're finding that in any of the case law. If you're saying it's not a per se taking because there's no invasion, you have to open your property to people who need healthcare anyway, and it's not at the level of Band-Aids or insulin, and it can't be Penn Central because there's still some economic use of your property.
So let me make two clarifying points that I think will address that. What we are saying on the per se claim is that Cedar Point instructs courts to look at whether this is consistent with longstanding restrictions on property. There is this tradition for hospitals of subjecting them to rate regulation, which operates much like charity care. So that analogy we're drawing, it hinges on the presence of a subsidy. That is what makes this analogous to rate regulation. If you took away the subsidy and it was like the landlord example, I think you wouldn't have that analogy, just wouldn't do as much work for you. So I think the fact that there is a subsidy is what brings this in line with that public utility tradition of rate regulation. What we've also said all along is that if the problem here is simply that the subsidy is too low, and the problem isn't that it's anything under 100, but that it went from 53 to 52%. If that's your problem, I think that is a classic regulatory takings claim under Penn Central, and we accept that that is an available claim. So I think that the presence of the subsidy is what forecloses a per se claim. But when you're making this more fact specific, the subsidy is too low for us and
It's as applied.
it's an as applied regulatory takings claim under Penn Central.
But has that ever been successful? I thought you also said you basically have to show no economic use for your property. So how could you possibly object to, 52 versus 53% if there's still some economically beneficial use of your property?
It's a difficult showing to make. And again, I don't think factor one under Penn Central is a bright line, but it is trying to kind of identify, is this looking more like a deprivation of all use of the property, or just sort of forcing you to suffer an economic loss? I think it's
so then it seems like we're back in the same place where, the legislature has not chosen to impose all of the burdens on a particular segment of society, but perhaps they could, because there wouldn't be any valid takings claim that a landlord could bring or a hospital could bring, even if the compensation was significantly less.
I think if there was zero compensation and it was just entirely putting the costs on a private industry member, I do think you would have a stronger per se claim, because that historical tradition argument would do less work for you. And I think for similar reasons, your claim under Penn Central would probably also get stronger. The character of the government action, I think, would also get stronger. The investment back expectations would probably get stronger if it was just something that didn't look like any past regulation, was kind of putting the entire onus of sort of the government's public duty to patients. It's sort of public health obligations. If it was trying to just offset that entire thing to private industry, I think all three Penn Central factors would cash out differently for similar reasons. So, and I think this gets at, both frameworks are trying to get at the same problem, which is the government sort of putting the entire onus of a public duty onto private industry. All these hypotheticals, I think they're very different from this case, and they may just present stronger arguments under Penn Central or the per se framework. I think because we're talking about hospitals, the per se theory is very difficult for petitioners to make, because it is sort of deeply embedded in this longstanding public accommodation, public utility tradition.
So I'm going to just go back to where we must feel like hours to you, but about a half an hour ago, I said, this is where I'm struggling. And I said, how much is too much? And the way you just answered Justice Waiter-Apter's question and was to talk about, it's a sliding scale, right? At some point, if you said 0%, but certainly you don't mean, I'm sure you don't mean zero. At some point, too much is a taking. And so we're now trying to figure out where that line is. And if we stick with Penn Central 1, and we talk about the economic impact for hospitals, there have been a number of different standards that have been used. Right? There is operating at a loss. There's, do you have the ability to achieve at least any economic benefit from your property? Do you have the beneficial use of your property? Or do you have, as the statute calls, are you able to provide quality health care? So that's a massive, massive chasm. And so what is the right standard in the first test of Penn Central? What standard should we be looking at? It can't be that you've just got to be able to identify, you may be able to make some profit here, but all the rest of your hospital can run in the red. Is the standard that your hospital has to be able to run in the black? Is there standard that the hospital has to be able to provide quality health care? Where do we look?
So let me try to give you a precedent answer and then ground that in some first principles. I would refer the court to Franklin Memorial, First Circuit, and the Ninth Circuit and Sierra Medical, which grappled with these exact questions on the Penn Central.
Sorry, what was the Ninth Circuit case?
Sorry, that was Sierra Medical Services Alliance versus Kent. We cite both of these in our supplemental
Thank
brief.
You may be the first attorney here yet who has ever argued that New Jersey is like Maine in any way.
I don't know that I'm going that far, but I will try to draw on the First Circuit's wisdom. In Franklin Memorial, in looking at the prong one analysis and kind of trying to identify what is the standard, the First Circuit explained there is no allegation that FMH, the plaintiff hospital, is presently facing any threat to its economic viability on account of the free care laws. And it said that while acknowledging the potentially harsh economic consequences.
So what does economic viability mean for a hospital? Does economic viability mean you're not bankrupt? Or does economic viability mean for a hospital that you're able to provide quality healthcare?
I think that really means more, are you able to operate with a reasonable profit? And that kind of in the rate regulation context, that goes back to how courts have always done a takings analysis with challenges to rate regulation. There are standards of
I thought a lot of these petitioners showed they were not operating with a profit.
I think what petitioners have focused on is the loss from these particular patients. I don't know that there's really been a showing of they are not operating economically viable as a whole. And this is what the appellate division grappled with. It acknowledged that they operated a loss for these particular patients. But, and this is, I would point the court to the Ninth Circuit's analysis in Sierra Medical. It explained that with a similar charity care-like law, plaintiffs operate at a loss when they serve Medi-Cal patients, but evidence of red ink generated by serving this one segment of California's population tells us nothing about the overall economic impact of that particular law. And so both of these circuits are—
That's the standard. Is that really a fair standard? Because a hospital could be cutting back on everything else in order to stay just barely in the black on its books, and not providing the quality of care that it otherwise could in order to accommodate the losses from charity care.
Well, so I think I would go to my sort of first principles point here, which is that the Fifth Amendment takings clause does not exist to ensure that businesses remain profitable. What it guards against is government takings of your property without just compensation. And so that's, I think it makes sense that the bar is quite low in these cases under either the per se or regulatory framework.
So is profitability, is being in the red versus in the black, the part of the standard?
I think it is part of the standard under factor
Sierra
one.
certainly suggests that.
Yes, I don't think, I think courts have not drawn a bright line, but and they've asked about economic viability, and viability, I think, turns on the extent to which you're able to turn a profit and continue operating as a hospital.
So a hospital getting 0% reimbursement, but is otherwise economically viable, would not be able to satisfy prong one?
I think they would still be able to show there's a pretty severe economic impact.
In Franklin Memorial, there was zero reimbursement, and they found no showing under prong one.
Franklin Memorial, I think, has, it's not an identical law. I think that there was some kind of reimbursement, some other indirect reimbursement. I don't believe either.
Oh, I thought from the case that the statute did not reimburse hospitals and did not limit the amount of free care that hospitals must provide. But the court basically said expenditures on free care are a small fraction of your overall budget. So even though you're getting 0% reimbursement, there's no showing that you have, quote, a present threat to economic viability.
Yeah, so I do think that is the standard that those courts have set up under prong one. Again, I don't think that is intended as a bright line, that they are trying to apply Penn Central's sort of spectrum of, does it look more like one or the other in this context of something that is sort of controlling the rates that hospitals can charge and receive. So I think I just to try and wrap this up, that these cases recognize it's a very low bar. You can imagine an as-applied claim coming closer to that bar. I don't think petitioners have really made that showing here. Their counsel acknowledged this morning that Penn Central was very difficult for them, not just because of that prong one, but because prongs 2 and 3 are exceptionally difficult for any hospital, really because of the nature of what charity care is, because your expectations that you can operate absent from this regulatory scheme are so diminished because it's just been in the law for so long and also is tied to these more longstanding regulations. Looking at all 3 factors together, I don't think any petitioners made that showing here.
Other questions, anyone? Anything you'd like to add, counsel?
No, thank you, Your Honor.
Thank you. Mr. McMillan.
Good morning, Your Honors, and may it please the court. Before getting into legal arguments, and I will do my best to avoid repeating what's already been discussed by the court, that may be a bit of a minefield because there are so many different issues that have come up. But before going there, we think a quick overview of the reasons that the charity care program is so important may be helpful to the court. In part because the public interest does matter, both with respect to the per se analysis as well as with respect to the Penn Central analysis. So big picture, charity care is a payer of last resort. It covers low-income patients who for one reason or another fall through the cracks and aren't fully covered under Medicaid, Medicare, or private insurance. And that can happen for a number of reasons. There are gaps in Medicaid coverage, which do vary over time. Hospitals don't always fulfill their obligations in assessing potentially eligible Medicaid patients with establishing their eligibility. There's a 2-year gap, a waiting period between when somebody is found eligible for SSD and when their Medicare coverage begins. And that's often a period where somebody just doesn't have healthcare coverage, even though they need it very much. There's a sort of similar 5-year period that lawfully present immigrants go through before becoming eligible for Medicare coverage. And increasingly, private insurance policies have left covered patients with substantial obligations and liability, even for covered hospital services. And we see that more and more often in legal services, that's a significant problem for folks who have been to hospitals. Charity care provides substantial individual and community health care benefits, reaches many people with disabilities and with chronic conditions who would otherwise not have access to any affordable health care at all. And it's only the most economically vulnerable patients who are eligible for charity care. Full charity care coverage is for those who demonstrate household income below 200% of the federal poverty level. And there's partial coverage for folks who show that they're between 200 and 300% of the federal poverty level. And there's also an asset test that goes along with applying for charity care. And the income thresholds parallel the very households that LSNJ's most recent True Poverty report found to be facing true poverty in New Jersey, those who are under 300% of the federal poverty level. So when folks have talked about, well, can you go out and is there a problem with not being able to recover from charity care patients? The fact of the matter is charity care patients don't have the money to pay. So the ability to send a bill, to file a lawsuit is of attenuated relevance where you're dealing with folks who just don't have extra money available to make the payment. It's also important to recall that hospitals receive substantial support from a number of types of sources, both from the charity care.
I think petitioners would agree with you that charity care is incredibly important and that there is a significant public need for it. I think their position is simply that because there is this significant public need, it should be paid for by the public as a whole, not just by specific individual hospitals. And that does seem like the purpose of the takings clause. It's not to ensure that expenditures are not made for public purposes. It's to ensure that public purposes are paid for by public expenditures that are collecting equally from everyone from taxes, and not just by imposing the entire burden on one particular property owner or several particular property owners. How do you respond to that?
Yes, and the basic legal principle here is that the public interest does matter in when some particular providers can be required to contribute to the public need, and when that public need should be spread over everybody so that particular providers don't shoulder any more burden than anybody else. And I think my colleague from the Attorney General's office did a good job of sketching out that it's a relatively small realm of types of businesses that may have that obligation to contribute to the public need. But it exists, and it's important, and it has historically been an important aspect of takings clause analysis, both for per se purposes and for Penn Central balancing test purposes.
Where has it been used for per se purposes?
I'll get to that. Shifting over to the issues that come up in the Horn case, and the Horn is the Raisins case. It essentially looks to the personal property that the hospitals say they're losing to charity care, and that the taking here is a taking of personal property. And historically, there's a long line of cases holding that when the public interest is significant, that's a place where economic regulation, including takings analysis, is particularly important. We see it in various types of price regulation cases historically, as well as takings cases and other types of cases, which we'll get into about that particularly involve hospitals. So, going back to the 19th century, courts found that price regulation of ferries was appropriate because there had such a high public importance. Price regulation of milk has been found specifically by this court to be appropriate because it has it's an important item to public health. Grain regulation of grain elevator prices, and then we get to more modern examples like zoning and rent control. All of those types of regulations have been found to be appropriate with the girding in the public interest that's being recognized. And it's not just any public interest, it's a really important public interest. So in 1963, this court recognized that in New Jersey, hospitals are operated not for private ends, but for the benefit of the public. And that's very different from just about any other type of business. Raisin farms in California aren't operated for the benefit of the public. Hospitals in New Jersey are operated for the benefit of the public. So unlike raisin farmers, hospitals are imbued with a public interest. And here we get to an interesting point in the Horn case, and it interrelates with another factor of hospital regulation in New Jersey. Hospitals in New Jersey have to have a certificate of need. They have to apply for and receive a specific special grant to be able to be a hospital, in part by showing, yes, our community needs a hospital. They also, in the process of getting a certificate of need, say, yes, we will provide healthcare to everybody in the community, regardless of ability to pay. When that certificate of need is issued, it reinforces that that's part of the obligation. So hospitals get special kinds of licenses, which also give them a special kind of economic advantage, if you will. There's a barrier to entry in the hospital industry that doesn't exist most other places. It's not exactly a monopoly, but hospitals exist in New Jersey in a competitively restricted environment, which gives them a bit of an economic advantage, in addition to their tax advantages, in addition to the fact that they solicit contributions from their communities. Hospitals bring in economic benefits from lots of different sources, as well as payments that they're paying patients and that insurance companies make to them. So the certificate of need is there.
Counselor, on this
Yep.
issue of public interest that you're talking about, the statute that we're discussing, charity care statute, says it is of paramount public interest for the state to take all necessary and appropriate actions to ensure access to and the provision of high quality and cost-effective hospital care to its citizens. Would you agree with that statement that that is the public interest that's trying to be espoused by this statute?
That's certainly part of it. Yes. And I think I'm coming, this was, I forgive the prelude, but this is coming back to Justice Wiener after's question. In Horn, the Horn case took great pains to distinguish another prior Supreme Court case called Ruckelshaus versus Monsanto. And that gives us one of the examples of where in takings law, these public interest important issues become so important. The court in Ruckelshaus versus Monsanto, the basic issue was that manufacturers of pesticides, fungicides, and one other kind of dangerous chemical said, the regulations you're imposing require us to provide safety information to the public. That safety information is part of our trade secrets. Those trade secrets are property, and if the regulation makes us reveal them to the public, you're, in essence, taking our property. So it's a taking of property that is certainly not real property. So it's much more like personal property than real property. And the court said, yeah, that's property. It's being taken, but there's no just compensation here because the public interest that's being recognized by this regulation is the health and safety of the public. I can read, manufacturers were not subject to a taking of their health, safety, and environmental information because they received a valuable government benefit, a license to sell dangerous chemicals. So Ruckelshaus versus Monsanto says, if you have an industry, the government is giving out special licenses to that industry, and they have to give up a little something in that licensing process in order to meet important health and safety concerns. That's not a taking that requires just compensation. And the court in Horn took a substantial piece of its decision to distinguish that case, and that's where the Chief Justice Roberts quote that raisins are not dangerous pesticides, they're a healthy snack.
But let's say the government had a very important public use for dangerous chemicals, because it just does not seem like it's on all fours. It seems like our situation would be more akin to the government saying, we need these dangerous chemicals, you make them, you receive this, benefit from us, you have permission from us to make them, and so you have to provide up to 43% of your chemicals or something like that to us, so that we, as the government, can use them for this very important public purpose.
Well, that's perhaps narrowing in on the charity care part of hospital operations rather than looking at the bigger picture. But it's certainly the case that if hospitals can turn patients who need healthcare away because either they have information that they don't have the ability to pay or think they don't have the ability to pay, consequences are those people can die. I don't
think anybody here is arguing that they should.
But it's on all fours with Ruckelshaus versus Monsanto. And the concern there for the important public health and safety issues that are being.
But it doesn't seem like it's on all fours. It seems like it would be on all fours if the government said, and therefore we're going to take a large portion of your chemicals because we need them for this very important public purpose.
They say we're going to take some of your trade secrets and make them public. And in the charity case, we're going to take some relatively small proportion of the care that you provide and make that available to the people who need it. And that's where we would say that the analogy resides to Ruckelshaus versus Monsanto.
But there are cases that come much closer, I would respectfully suggest, than that.
Pardon?
There are cases that come much closer that have been talked about today that come up than that analogy. But let's move on.
Well, we would urge the court to think about that analogy some more because it's an important one, and it certainly is central to the decision in Horn, which in turn is central to the hospital's arguments here. There was a question, I believe it came from, I'm sorry, I forget I forget how it came up, but a question about history. It may have been Justice Weiner after this may have been your question as well. What other examples are there of history being important in the takings law analysis? And one, I'll come to attorneys in a minute, but another example that hasn't come up yet is dry beach access cases. And it may seem like the analogy is rather stretched here. It's not meant to be a close factual analogy, but it is an illustration of history being important in deciding takings law cases. And the basic issue is whether regulations that say the public has access to that part of the beach above where the tide ever reaches, what's called the dry sand portion of the beach, is taking the property from somebody who owns that part of the beach. And just long story short, Oregon led the way with this and said, we have a long history of the public being able to walk on, to have access to dry sand beach. And Oregon Supreme Court said yes. So that's really a background condition, no taking if a regulation gives, provides access to the dry sand portion of the beach. Other states are very different. Some of the major takings cases that
right, isn't Nolan one of the major
about that? And Michigan has said something similar about its Great Lakes shores, and New Jersey is the other state that has pretty significant law here. It hasn't looked back at the history in quite the same way that Oregon did, but New Jersey, by and large, protects public access to dry sand beaches as well. So that's just an example of history being important in doing a takings law analysis. And the situation with attorneys, folks have talked about that a fair bit. I'll just add in that this court addressed the issue of whether the Madden versus Delran assigned counsel obligations work a taking. The court said, yes, there's a property right there. And no, it's not a taking. It does not require just compensation. It's part and parcel of an attorney's obligation, in part based on on deep history. And it's not exactly the same, but we see that same similar kind of deep history in the hospital context. And Madden quoted an earlier case, State versus Rush, and this is in our brief. If one accepts the premise that the duty to defend the poor is a professional obligation, rationally incident to the right accorded to a small segment of citizenry to practice law, these takings claims fall away. If that seems, there's a very closely analogous historical analysis. I think the other major per se takings point here is Cedar Point. And we lay out in our briefs the reasons why New Jersey should be recognized as having a background condition saying that hospitals do not have the right to assert their boundaries as a barrier to healthcare. We take a different view of the Shack case than the petitioners. The Shack case involved, among others, a nonprofit employee of a nonprofit health provider who wanted to go onto a farm to provide health services to a farm worker who worked there. Farm worker said, no, can't cross over my boundaries to come and provide health care. And this court said, sorry, the boundaries don't get in the way of providing health care. Doe versus Bridgeton, quite similar. Hospitals said, we want to be able to prevent potential patients from crossing over the boundary into our hospital to receive reproductive health care services. And again, the court said, no, boundaries to the hospital don't add up to the ability to keep somebody from getting healthcare services. And other cases in that general, on that general principle have generally involved hospital decisions to keep certain providers out of their hospital. And this court has consistently held that hospitals can't keep certain providers out if that prevents patients from being able to access healthcare services at their hospitals. So there's a long tradition of the right to exclude in New Jersey not being applicable to healthcare services. And we argue that it goes so far as to be a background condition which hospitals simply do not have a right to exclude folks.
But there's no argument here, as I understand it, on the part of the hospitals that they have the right to exclude anyone who needs medical care.
Interestingly, they do. And they cite about a page worth of cases in their response to our brief for a point that counsel alluded to in his argument, the common law right of hospitals to exclude.
They are not asserting, as I understand it, and there's going to be a rebuttal, a right here to exclude any patients.
While I'm talking, I will see if I can look for the page number in their brief, but they cite about a dozen cases.
With regard, though, for example, to
common law
places of
right
public
hospital system.
accommodations and innkeepers and no right to exclude, it seems like their point is, in none of those cases does it say that a common carrier has to accept someone and not bill them for the services. They are fighting for the ability to receive payment or to bill someone for payment, not to exclude someone to begin with.
Our point would be that New Jersey's rule about the right to exclude is strong enough that it doesn't bend to this right to be able to bill customers, frankly, customers who rarely are able to pay in the first place.
But no other case has said that, for example, right? So there's no case holding that a innkeeper has to admit anyone and allow them to sleep in the room even if they can't pay.
Well, Heart of Atlanta Motel would certainly say an innkeeper cannot exclude someone because they think they're not going to be able to pay.
No, but Heart of Atlanta Motel says you cannot exclude based on race. It doesn't say you can't exclude based on inability to pay. So if someone were to come and say, you know, I want to sleep in your hotel room, presumably the hotel says, okay, it's $100. Heart of Atlanta doesn't say, if they say I have $0, that you still have to allow them to stay over.
And this falls into a somewhat complicated realm. Forgive me, I'm thinking of without going to a much longer discussion, a shorter answer to that question. The cases say, sorry, you can't erect your barrier to keep people from getting healthcare services. And our position is that reflects New Jersey law, whether or not there's an ability to pay. And I do see it as here at pages 10 to 11 of the petitioner's response brief. They cite cases from maybe 10 other states for the proposition that hospitals have a common law right to exclude individuals from their premises. So they are arguing that. None of those cases are from New Jersey.
Counsel, in the interest of time, I want to ask you to move on to any remaining points and try to do those in fashion.
There was a lot of argument before, so thank you for bearing with me. One further point that we didn't quite get to was the Houston case in which Atlantic City casinos were held to be required to allow anybody who came onto the premises to do what the casinos offered to the public, which is play gambling games, to come onto their premises, whether or not they thought that they could make a profit from them. So Mr. Houston was a very good blackjack player. He was a card counter. The casino said, we want to be able to bar card counters. There's a little bit of an argument back and forth about this in the brief, but their position was they alleged that they could not make any money from a card counter. Therefore, they wanted to be able to exert their right to exclude and not allow a card counter to come onto the premises. And the court did something that's unique. Property professors, some property professors teach this as a unique aspect of law in New Jersey and held that public accommodations in New Jersey have to be open to everyone who wants to access the services that the public accommodation is offering.
Correct, but they still allowed a charge. So there was no holding in that case that he has to be able to stay in a hotel room for free if everyone else has to pay for the hotel room.
I think the one exception, there is an exception there for where there's a ticket price, where there's an upfront price, and that's crucial to the model of the business staying in business. That probably works as an exception. But that's not the case here. Hospitals aren't going to go out of business because they because they don't have that right to exclude. And the people who are the patients who are seeking charity care are coming to the hospital for the very services that the hospital provides to the public. Our position would be that New Jersey law says, turning someone away with its extraordinarily serious consequences, up to and including death, based on the right to exclude, which is the sole basis for the Cedar Point decision, is not part of New Jersey law, and that accords with the Houston holding that public accommodations do have to be open to the public generally, except to the extent that admitting certain people would prevent the public accommodation from being able to offer its services at all. And that's certainly not the case with respect to New Jersey hospitals.
Thank you, Mr. McMillan. Mr. Jackson, brief rebuttal.
Can I just start with a question? I know you have points on rebuttal. Is your client or your clients making any claim that they have the right to exclude patients who need medical care?
I'm going to give you an answer in two parts. There is no claim of an absolute right to exclude patients who need medical care. The right to exclude has been limited, but not eliminated by the development of the law in New Jersey. For an example, while a person can come into the lobby area of a hospital, go to the gift shop, under a under a public accommodation analysis, that person does not have a right to go into the operating room or to go into the X-ray area unless they are being taken there for the purpose that the hospital is in business for. So there still is, in terms of what we've been hearing about background principles of property law, the background principle of property law is that the hospital has a right to exclude, which over time has become limited. Okay, so that you, on the basis of race, you cannot exclude. On the basis of sex, you cannot exclude. On the basis, as we have it from the Take All Comers statute, on the basis of ability to pay, you cannot exclude completely. But what happens once a person is in the hospital is different. There still is a right to control of the property.
I was asking purely about people seeking medical care who need it, and presumably not people who are perfectly healthy trying to get into the operating room.
Well, but even if they are not healthy and they need care, they still have to be accepted as patients.
Thanks. Please go on.
Okay.
With your points on rebuttal.
And I think that to just finish up on the public accommodation issue here, the cases like Doe and Shack, demonstrate a right of access. But as the justices, several of the justices have recognized, they do not address at all the ability to get charged or to be reimbursed for the services that are provided. So those are not dispositive of the issues here. The rate setting analogy, I think, is inept because, first of all, there is no New Jersey case that recognizes hospitals as public utilities. That's an analogy or an analysis we have urged. based on academic writing. But there's no case that says that. But even if there were, fundamental to the public utilities issue in the context of takings is that there is a right to fair return. And there is just no way that you can say there's a fair return that you cannot cover your costs or have your costs covered in some way, such as the state subsidy. And again, come back to the fact that it is the state's obligation here, fundamentally, to provide access to the care and the opportunity for quality care and to provide a subsidy. It's right in the statute. Okay, the extent of the subsidy is something that depends on the facts that one wants to look at. In our materials, in the appendix, and this is 634A, which analysis of Englewood Hospital's charity care shortfall. They received 6% of their care.
I think your adversary's point was there's nothing about the profitability of the hospital as a whole. There's only analyses of charity care shortfalls. Do you agree with that?
No.
So where in the record can we find information about the hospital operating at a loss as a whole, or not being profitable as a whole?
Okay. We have submitted the report of Stephen M. Philibrown, starting at 766. In particular, I think 795, there's a summary that talks about the impact on the operation of the hospital as a whole because of the charity care shortfalls. They're still able to operate. But it cannot be the law that you have to go bankrupt in order to have the takings cleared. That cannot be the law. Now, there's a comparison of what the profit margins, the liquidity, and these economic tests analyzed by this financial person who used to be in the Department of Health.
He says profitability, liquidity, and leverage are the three factors, and he goes through all that.
Yes. Okay. And he shows that there's an adverse impact. Does it completely eliminate it? No, but it's getting close. And that is precisely the problem that is driving the concern here. You know, how viable will the hospital industry be in New Jersey? The court can take judicial notice that hospitals have closed for financial reasons in the state. We used to have like 142 hospitals. We're down to 72. Some of that is the result of certain business decisions, but the access to that care is decreasing. And again, the state has articulated its responsibility to provide and to ensure that there is quality hospital care. The tradition of free care is, I think, a slippery thing to hold on to. The tradition of providing free care was not unlimited to anyone at any time, at any cost. You know, the tradition comes out of a choice to provide the care, not being compelled to do it. And again, this court has said hospitals are required, you say mandated, compelled, whatever word you want to use, it's not a choice the hospital can make. Now, many professionals make that choice themselves, but how can that possibly be a reason to deny the entitlement to be reimbursed or compensated for the work that is done? reliance was placed on Franklin Memorial and also the Sierra Medical cases. Those cases rejected a per se approach, a physical taking claim. We suggest that those analyses were wrong. That certainly in Franklin Memorial, the basis for the physical taking is laid out in the court's summary of the facts of that case. And it erred, we think, because it predated Horn. Horn changed the way to look at these cases, to recognize that it's not just a single piece of gauze that is the personal problem. It's a whole litany of items of physical property, tangible property, intangible property that are being taken and used for the care of the patients that is at issue here.
I think your adversary's response to that, I'm sorry, was that you can't look to small pieces of physical property within the hospital. You have to look at the hospital as a whole. So it would only apply if they took the hospital as a whole.
I understand that that served their argument. And I think that argument is wrong because the case law from the Supreme Court of the United States is that if we are talking about a physical taking, the concept of looking at the property as a whole does not apply. And I believe the case that supports it, we briefed that in our brief, but as I recall, the case would be Kaiser Aetna.
Mr. Jackson, because we're on rebuttal and we've exceeded the time you had reserved, I'm going to ask you to just give us clipped highlights if you have any remaining points.
The last point relates to whether or not the state completely regulates prices, and that is a basis for justifying the charity care. That's not accurate. The state does not regulate all prices. You know, if there is a program that a governmental program like Medicare or Medicaid, you know, the state is regulating those prices, or government is regulating those prices in terms of Medicare. But there is, in terms of what prices are to be paid for services by a private insurer, the state doesn't regulate those. And if there's no insurance that's involved, and we're not talking about someone who's qualified for charity, there is no limit on what a hospital can charge. And it's Third Circuit DiCarlo case that says that. Not that it's the Wild West, but you know, it's an overstatement to say that these prices have been so tightly regulated, you never should have expected to get as much as 43%, which is what the statutory baseline is, which has not been achieved. Now, testimony of the Department of Health representative that we took in deposition says that there were years when it was 1%, and the state rarely met the 43% target. So, Chief Justice, with that, I would say thank you for your time today.
Thank you. And thank you to all counsel for the very fine presentations this morning and into the afternoon. We will take the matter under advisement. We're in recess.